Hello, and welcome to So Neighbor Asked, a monthly series from Mountain States Legal Foundation, where our attorneys answer your questions to help you understand the Constitution, the law, and the principles of liberty. I'm your host, Stanton Skrjanik. I'm the communications manager here at Mountain States. Before we begin, I just want to tell everyone who we are as Mountain States Legal Foundation. MSLF is a nonprofit public interest law firm dedicated to restoring those rights enshrined in the Constitution at zero legal cost to our clients. We are focused on protecting property rights, economic liberty, the right to keep and bear arms, free speech and association, and equality under the law. We hit a lot of targets. From our headquarters in beautiful Colorado, we litigate very crucial cases across the country at every level. Especially ones that are going to make a difference in our country. Today, I am joined by Mountain States attorneys Will Trachman and Kaitlyn Schiraldi. Howdy, you two. And Will, we have a special guest with us today. Would you please introduce her for us?
I'd be honored. So we're here with Sarah Parshall Perry from the Heritage Foundation. Sarah is a patriot, a mom, an energetic defender of liberty, and I had the honor of working with her at the U.S. Department of Education. We were both political appointees under President Trump and Secretary of Education Betsy DeVos for some time, and we worked on issues like Title IX together. So it's a pleasure to have her with us here today to talk about Title IX and many of the issues that are arising right now with the Biden administration.
Welcome, Sarah. Welcome.
Thanks for having me. I'm very, very glad to be here.
Fantastic. For our viewers online, after we chat here for about a half hour or so, we're going to have a question and answer session to close out the episode. If you are joining us here on Zoom, you can find a little kind of Q&A button at the bottom of your panel where you can ask your questions. And if you're joining us on Facebook, we're going to try our best to grab your questions from the comments. So feel free to drop a comment, like the page, do whatever you need to do to get our attention. Okay. Will, Kaitlyn, Sarah, let's get to our question. So a neighbor asked, what is Title IX and does it interfere with the freedom of speech? I like to think I know what freedom of speech entails, but I am very not knowledgeable in Title IX. I know it has something to do with women in sports, but there's got to be something more to it. What is Title IX?
Well, Title IX is a civil rights act. It is a federal law that was passed in 1972 and bars sex discrimination by recipients of federal funds. Most of the time when we're talking about Title IX, we're talking about schools, but actually a lot of other federal agencies incorporate the definition of discrimination under Title IX into their statutes. So when you're talking about healthcare under the Affordable Care Act, for instance, they're incorporating what sex discrimination means under Title IX. And so Title IX is actually incorporated in tens of places throughout the federal code. So it has a pretty significant impact on federal regulations overall. We are going to be talking about speech because a lot of the recent conduct by the Biden administration impacts how teachers and schools and school districts have to refer to students, have to embrace subjective notions of what the students say about themselves. So it's not just the students having the speech on their own, it's what the teachers and administrators and other school personnel have to do and have to vocalize in order to comply with the Biden administration's version of Title IX. Sarah, do you want to talk through your experience with Title IX? Obviously, Stan's heard of the women's sports issue. I want you to be able to weigh in on that.
So I think a lot of us sort of colloquially think of this as the sports bill, right? Because it's been used to such great effect to give girls and women an equal opportunity to perform in interscholastic athletic associations and endeavors. But it really does encompass so many other aspects, everything from housing to admissions into graduate school programs and scholarship opportunities. Any educational format that receives so much as $1, directly or indirectly, of federal funding is subject to Title IX. So you can imagine that's quite a few series of colleges, institutions, public schools, vocational schools. So it's got a real broad reach. And, you know, at the time, it was really sort of considered a feminist achievement, right? This was what the feminist movement had worked so hard for. not only in non-discrimination under Title VII, that was something that they were a motivating force behind. They also tried the ERA, which to this point has been unsuccessful, but Title IX was sort of the crowning achievement, right? We know that education directly impacts later success, future in life, but there have been studies that indicate 92% of female executives, these are C-level executives in the C-suite, right? So your CEOs, your COOs, have played interscholastic sports, either in the high school level or have played it at the college level. So that connection between education and athletics is really a very close one. And one of the things I think that we're most concerned with here at the Heritage Foundation is the fact that the fundamental definition of sex as being our understanding, plain and ordinary meaning of that term as passed in 1972, male and female, is being expanded by the Biden administration to also include sexual orientation and gender identity. And the gender identity notion itself really puts a fine point on the sports issue when we look at athletic advantages.
Now, I know we're gonna talk a lot about the definition of sex, and I know Kaitlyn, you've got some really strong comments on this in our discussion in the past. You mentioned 1972, 1973. So it's been around for a while. No, they just celebrated its 50th. If I'm doing math right, 50th anniversary. What's kind of been the history? Because I imagine it was pretty somewhat controversial then. And now it's hitting controversy again with the topic of today. What about the kind of intervening, 40, 45 years? What was the history of this? Because it's a short law, but it's a really expansive law.
I wanted to kind of hit on the success that Title IX has had, up until the proposed rule. This comes from one of Sarah's articles that I read on this subject, and female participation in high school athletics is 10 times what it was in 1972. So some stats from ESPN said that in 1972, there were 300,000 female high school athletes, and in 2022, we had 3.4 million female high school athletes. So it's quite a success. And going back to what you were talking about, saying, where did this start? What is the history? There are a lot of dictionaries from the 70s that claim exactly what we know to be true, that sex was meant to be biological sex. In fact, there was an 11th Circuit case that was recently decided called Adams, where the court laid out a bunch of different dictionary definitions from the 70s, where sex was determined by your reproductive functions, which is how we understand it. And now the Biden administration has completely flipped that on its head.
So historically, we're talking about the binary biological sexes, male and female, and I imagine that's how it was commonly used over history. I know we talked about sports a lot, and Sarah, you mentioned some housing and some other things like that. What are some of the other more common areas that we see Title IX pop up, either in in other litigated cases or in some other dimensions? Where else are we seeing Title IX being most prominently used besides athletics?
Well, Sarah's commentary is really interesting to me because obviously at Mountain States, we don't deal with the idea of women's sports directly, and we don't deal with even sexual orientation and gender identity issues on a direct level. On the other hand, we do have a thriving First Amendment practice where we tackle speech issues, and that's why we're doing this webinar today. But it's actually very difficult to carve that issue out. As Sarah was mentioning, these are overarching questions that have to do with fundamental inquiries about what is sex and what is sex discrimination. And so it's a very interrelated question to say, do women have an equal right to compete in high school or college athletics? And then all of a sudden, do teachers have to acknowledge they, them pronouns on the basis of sex, right? These questions are all under Title IX, which is a very short statute. But these questions are arising. And so it's hard to separate them entirely. Of course, Mountain States is dedicated to the First Amendment, and Sarah is doing yeoman's work in the women's sports area. So we wanted to make sure that we covered all of this rather than try to splice off one narrow aspect of Title IX.
Which, and that's absolutely important. We're going to get that First Amendment. We're going to hit that on the head today. One thing, because I had to do my own research on this, because again, I don't know. I barely know this thing. it's what, like 40 words or less, and it's not just about, what'd you say, Kaitlyn? 37?
37, yes.
37. Okay. 37 words, and it's not just about opportunity. It's also, like Will, you said, discrimination and harassment. Now, I know that we're not a workplace or a discriminatory litigation place, but what does that mean? What does discrimination, harassment, like, legally mean? Like, I know what it means when someone bullies me. I mean, when I was a kid, I hope, thankfully, I don't anymore. But, what does that look like? What is that legal idea?
Well, in a Supreme Court case called Davis versus Monroe County Board of Education, they said sexual harassment essentially equals sex discrimination. Title IX is an anti-discrimination statute, and this test is a 3-part test. So it looks at whether or not the action was 1, severe, 2, pervasive, and 3, objectively offensive. Each of those terms has its own definition. So severe, the court will look at whether it's physically threatening, is it humiliating, is it just offensive words we're talking about. Pervasive would be, a pattern or frequency. And then objectively offensive, the Fifth Circuit gave a definition for this, saying if a reasonable person would find it hostile and abusive. So that's the standard that was used prior to the proposed rule. And now the proposed rule just looks at whether or not the sexual harassment is severe or pervasive. And now they look at subjective offensiveness, meaning what the victim thinks is offensive. So that definition is apparently subject to change according to the Biden administration.
Okay. So we kind of have a court-based understanding of what it is to be sexually harassed or discriminated against. Okay, and now we have the Biden rule. We haven't really broached it yet. I know that during the Trump administration that they were dealing with this quite a bit. And Will, because you worked in the Trump administration on this very topic, what did that look like? How did President Trump and his Department of Education, how did they approach this question of applying Title IX and the whole question of speech and discrimination, et cetera?
Yeah, well, Sarah and I worked together on this, so it was nice to have a partner. And Sarah, feel free to chime in. So I'll take you even further back than the Trump administration. Under President Obama, the agency never issued any regulations on the topic of Title IX. What they instead did was issue letters. So they would post a letter on their website and say, this letter has the force of law, didn't go through Congress, didn't go through even notice and comment by the public, which is a lesser step than legislation, but at least allowable. Just a letter written by the bureaucrats within the Office for Civil Rights at the Department of Education, saying this now has nationwide effect. Those guidance documents said that sexual harassment, by contrast to what Kaitlyn just laid out, was anything that was severe or pervasive, that didn't use objectively offensive, and that a lot of speech could count as sexual harassment. Just a few years ago, I think you'll remember that we had a Supreme Court nominee who was accused, not credibly, of sexual harassment. And some schools were saying, well, he can no longer be a visiting professor here because that would be a Title IX violation. That would be sexual harassment to let someone who's accused of sexual harassment even be a visiting professor at the school. In a number of enforcement actions, the department really expanded what could be speech to the point where lawsuit after lawsuit was brought by individuals who were disciplined or expelled or worse, maybe had their transcript notated permanently because of speech. And so the Trump administration backtracked on that and said that the Title IX has to live harmoniously with the First Amendment and free speech protections. And so if something's protected by the First Amendment, you cannot expel that person for that conduct. Now, of course, a lot of private schools don't have to abide by the First Amendment, but at least that was the rule with respect to public schools. And then when the 2020 rule came out, which Sarah and I helped enforce between May of 2020 and January of 2021, we noted that there were a number of First Amendment protections. So, for instance, you couldn't be charged with retaliation merely for saying, I'm innocent, I didn't do it, I'm being falsely accused of sexual harassment. Some schools had said, well, you're calling the victim a liar, so you are retaliating against that person, and that's an independent Title IX offense. So the Trump administration got rid of that, to its credit, and then embraced the idea that schools could never comply with Title IX by suppressing speech. And I mean by that, they could never come to the Department of Education and say, look how strongly we're complying with Title IX. We have made sure that speech is suppressed everywhere on campus, right? The Trump administration said that is never a viable argument with the department. So a lot of good things. Sarah, do you want to add a little bit more?
Did I just hear that defending yourself, an important aspect of due process, was grounds for violating it? Hold on, Sarah,
Yeah.
How quickly this slope becomes slippery, right? So essentially one became subject to sort of an unspoken heckler's veto, right? You don't even have the opportunity to defend yourself when you're accused of violating Title IX through sexual harassment or sexual assault. And I think one of the things that you all are concerned with, as we are at the Heritage Foundation, is the fact that this is a muzzling. The proposed rule, and I know we're going to talk about that a little bit, by this administration is really going to muzzle people in what would ordinarily be protected speech. So I'm quite certain we're going to see a number of legal challenges brought on this, but it does platform things, for example, like preferred pronouns, which I will tell you, the Sixth Circuit has already said in a public university format that you can't be compelled in that intellectual academic environment, even though it's federally funded, to use someone's preferred pronouns, because that's a form of compelled speech. So there's a lot of intersection with the First Amendment.
But before we touch on preferred pronouns, because this is a really interesting subject when it comes to the First Amendment, I just want to make sure I get this clear. So this three-pronged test of, what was it, pervasiveness, how much it's happening, severity, right? How bad it is, and then what would you call it? Objectively what?
Objectively offensive.
Right. Any reasonable person says this is bad. So the court kind of already outlined those three prongs, and you're saying the Obama administration, and I guess now the Biden administration, said, meh, we only need two, and really only one of them. Is that what I'm hearing?
Yes, it's an either or, severe or pervasive, and now subjective offensiveness is considered along with objective offensiveness.
So subjective offensiveness isn't any reasonable person. It's, I think that hurt me, so I'm right. Is that what that means?
That's correct. That's how this new test either chills or compels speech. So you're either being forced to use biological pronouns, or your speech is chilled because you're worried about subjectively offending a student. So it's a dual issue.
Okay, so let me set up an example, because I think that'll clear it up. I know it'll clear it up for me, and I want to apply what you're all saying here, Will, Kaitlyn, Sarah. So I go to a public funded university. I Title IX definitely applies, and for whatever reason, I refuse to use someone's preferred pronoun. Under Trump's guidelines. I know there's a technical difference between the two.
Regulations. Yeah. Remember, it's the Obama folks that didn't use regulations. Trump corrected the error. Yeah.
I'm not even going to dive into that technical terminology. These rules, under Trump's rules, what happens to me if I don't use someone's preferred pronouns?
Well, you have to look at the three-pronged test, right? Severe, pervasive, or objectively offensive. And the end result has to be that you effectively deny the victim access to an educational opportunity or benefit. So just hurting your feelings is not enough. But if you're not coming to class because someone is physically threatening you at school, that would be something different. The example they give in one of the cases, it might have been Davis, where it said if male students physically threaten female students, so much so that they were denied access to, let's say, an athletic field or a computer lab, that's like the seminal Title IX case right there. But it gets murky when we're talking about pronouns now that the test has changed.
But if I, as a student, don't use their pronouns, or I use their non-preferred pronouns, right, with their biological ones, if I use them as a student, that it has to be so severe that they don't come to class. That under Trump's, that's what would classify as harassment, right?
Well, the rule is that mere speech can never be so offensive as to deny equal access to your opportunities. Now, on the other hand, if someone were following you around and stalking you around campus and shouting, he versus she or they versus them at you, then that's something different than speech, right? That's stalking or harassment. But it's not just announcing, I am going to speak a certain way and not speak the way that you want me to. And so you, as a student under President Obama, I think you'd have a real problem not getting at least spoken to, if not disciplined, or having your transcript notated. And that changed under President Trump. And now Kaitlyn just alluded to the proposed rule from the Biden administration, which is not final yet. We've filed comments objecting. I know Sarah has as well. And hopefully that rule will be not enacted, but if it is enacted, challenged quickly in the courts and joined.
Okay, so just to summarize, under Trump, if I use biological pronouns instead of preferred pronouns, I'm fine because speech is speech, and that can't qualify as severity as harassment. But if I had a bullhorn, I followed him around, then yeah, that would obviously be harassment. Under Biden and Obama, it could be harassment because it's not about actual harassment; it's about how the person feels internally. Does that summarize it pretty well?
Mm-hmm.
Okay. What if I'm a professor? What if that does that change now if I'm a professor? I used to be a high school teacher, so this came up for me. Does that change?
That's what Sarah was just talking about. The Sixth Circuit case is called Merriweather versus Hartop. And the court said that the professor cannot be forced to use pronouns. And the same issues have been litigated even for teachers in high school. So Will and I both wrote 2 amicus briefs actually for the Vlaming versus West Point School Board case, where a French teacher was fired for not using biological pronouns. He was very pleasant. He called the student by her preferred name in French and English. And they were doing a virtual reality goggle session at school where the student almost ran into some lockers, and he said, "Don't let her hit the wall." Well, this girl had transitioned to a boy. And that one instance, coupled with just refusing to use pronouns in general, but just referring to her by her new name, was enough for the school to fire the teacher. So it's happening all over the place, not just professors in universities, but also teachers in high school.
So Sarah, so thank you, Kaitlyn, for clarifying that. You mentioned that Sixth Circuit case. If you would indulge me, what's the devil's advocate argument? Why is the Sixth Circuit wrong? We all think the Sixth Circuit's right. Why would someone say the Sixth Circuit is wrong? Help me play devil's advocate here for a bit.
Well, I think all you have to do is look to the Biden administration and read their proposed rule and every piece of press that comes out of the Department of Education that talks about individuals who have sort of this incongruence with their gender identity, people suffering from gender dysphoria, and say, listen, it's stigmatizing not to be able to, for example, use the bathroom that they want to use, or in this case, receive the pronoun use that they want to use. And we've essentially watched the manufacturing of this crisis that Title IX has never caused. In fact, Title IX was passed distinctly to protect equal opportunity for males and females, and to essentially provide that equal protection basis for both sets of individuals, because again, we know that people provided educational opportunity who are not discriminated against, kept out of programs or kept out of admissions pools, they do better in life. It's naturally, directly correlated one to the other. But the devil's advocate position is, these are individuals who already feel bad about themselves. They might have this, gender dysphoria or gender identity disorder. And so we just want to make things as easy as possible. But to turn civil rights law on its head in that exact basis, and civil rights law has never operated to protect individuals' subjective identities. The Supreme Court for years has used the standard of what are called immutable characteristics as the foundation for equal protection. In other words, what the court has called something that you have by accident of birth, your race, your national origin, your ethnicity, your sex. These are things that have, prior to this point, never been up for debate. And yes, there are individuals who experience that gender identity disorder or gender dysphoria, but not on the scale that we are currently seeing it represented by this administration. And that is, I think, a very big concern, that we stand to upend the entire paradigm of American civil rights law and will identify correctly that Title IX isn't just education. In fact, so many other federal statutes take their definition of sex discrimination from Title IX. Healthcare, family law, accommodations law. There are so many statutes that incorporate by reference Title IX that it really would set off a domino effect that would be hard to slow down.
Stanton, you're a braver man than me asking Sarah to argue for the devil. But Sarah, what's funny is that some of the opinions that you cited are either arguments made by the late Justice Ginsburg or actually written by Justice Ginsburg in her opinions from the 1990s.
Yeah.
Obviously, the notorious RBG, right? So, what do you think about that? Has the sea shifted in the last 20 years?
I think it has, unfortunately. So, looking at Justice Ginsburg herself, and I think it was U.S. versus Virginia, the case about female admissions at West Point Military Academy, she discussed the immutability of sex and how it couldn't be easily swapped for one characteristic or one category or another. So even sort of the liberal lions like Justice Ginsburg recognized sex is a category to be protected. And here is why. We're unfortunately seeing that very commonsensical position held by conservatives, libertarians, liberals alike from the past 20 years begin to fall apart.
One thing that I've always found interesting about this discussion, especially now that I'm being educated on Title IX here, is two things about one, how Title IX was all what, like you said, it's a kind of a feminist achievement. It was to carve out a space for women in that public domain. But the other thing that I'm trying to wrap my head around is, okay, let's say that I'm not saying we do, but let's say that we have this objective of trying to protect those individuals who might have gender dysphoria. Okay, it could be a worthy goal. Why try so hard to redefine the word sex? Why not just go to Congress and say, hey, please add this into legislation, create a Title 9B. Please amend this. Why are they trying so hard to reshuffle definitions that have been in place since at least the 70s? Why bother?
Talking with common sense. How dare you? How dare you have a rational approach to a situation like this? Now, I think what we can do is we can look at, and this is something, that's germane to the entire discussion, the Supreme Court's decision in Bostock versus Clayton County, dating from 2020, which was an employment decision case. And believe it or not, I don't think a lot of people remember this part of the decision, but Justice Gorsuch began his majority opinion saying, we're going to accept that sex means biological distinctions between male and female. But because under Title VII, any reliance on sex, even a 1% reliance, is prohibited, that he would consider, and the court would consider, discrimination on the basis of sexual orientation and gender identity or transgender status to also be sex discrimination. Well, that administration, the current administration, took that decision and ran with it. And on the first day of his presidential administration, Biden issued an executive order directing all of his federal agencies to take that interpretation of sex and expand it to sexual orientation and gender identity. We are talking hundreds of federal statutes that use the terminology sex discrimination. So you can see how this is really a significant effect from one very limited interpretation. And the Supreme Court was very careful to limit it. In fact, Justice Alito said in his dissent, this is going to have a huge effect just beyond and into even education. And Justice Gorsuch said, and I have talked about the fact that maybe his approach to textualism, taking the law as written, wasn't great in this particular case. But he actually wrote, we are only talking about Title VII. We're only talking about employment discrimination. We're not making a judgment on anything else, including speech, dress codes, anything of the kind. So it was almost as if he was raising that white flag, saying, listen, we're not talking about the other things that are naturally going to be implicated. But unfortunately, that limited holding has gone apparently unnoticed by the current administration.
And after that executive order that Sarah was talking about, the department issued a notice of interpretation where they said, well, Bostock, it must apply to Title IX. And the state of Tennessee and 19 other states sued and said, no way, you created a regulation out of whole cloth. There's no notice and comment. The court agreed with that in the Eastern District of Tennessee, and now the feds are appealing to the Sixth Circuit. But yeah, people were very unhappy after that executive order came out.
So we're ignoring the 3-prong test. We're not following the typical procedures that a regulatory agency has to go through. We're telling Congress we know how to interpret your laws better than you. And they looked at Gorsuch and said, hey, thanks for something that you didn't give us. Am I missing anything of the insanity here?
Well, notice the move and logic that Sarah was pointing out just a second ago. It's one thing to say you can't fire someone for identifying as transgender, right? It's another thing to say you have to affirm someone, regardless of your personal beliefs, whether they're religious-based or not religious-based. And you have to believe that they have switched genders, or it's discrimination, right? So if a school said, we don't want transgender students on the chess team, right? I understand, that's not a viewpoint that is consistent with Bostock if you take Bostock from the employment context and put it in schools. But even if you accept that, that's very different than saying if someone says they're a woman on day one with no hormones, nothing else, just identification, you have to believe that they're a woman. For student trips where you have to put students in hotel rooms together, for locker rooms, for bathrooms, for showers, for sports teams. And pronouns, of course, and you have to affirm those pronouns. That doesn't even get to the point that there are 72 genders now. And so the Biden administration's notice of interpretation would say the teacher has to memorize and use all those pronouns, none of which are, of course, mentioned by the Bostock decision. They're just extrapolated in the notice of interpretation that Kaitlyn was mentioning. So students switch pronouns. That happens these days. Students invent new pronouns, whether it's at the K-12 level or the college level, and teachers and school personnel who don't memorize those pronouns and use and affirm those pronouns are liable under Biden's Title IX policies.
Yeah, forget whether or not any of the pronoun thing makes sense. Forget that. On the very fact that I would have to be required to use them, that's what brings us to the main constitutional issue of free speech, right? Is that okay?
There are a lot of constitutional issues just besides free speech. So if anyone would like to read Will and I's 35-page comment, they're more than welcome to, where we discuss a lot of other constitutional issues, but speech is a big one.
Before we go on, just as a reminder to everyone, if you have any questions, because I can't be the only one who's got questions here. I know that a lot of our viewers do. If you have questions, please feel free to put them into the Q&A down at the bottom. We'll get to them here in a little bit. We've got a couple of more topics to cover here, but I just want to remind you to ask your questions either down in the Q&A or on Facebook in the comments. We'll definitely get to you. Okay. I'm going to ask something so I used to teach government, so I kind of understand free speech because that was one of the big things we did. One of the things about free speech, and again, tell me if I'm wrong, is that the court has in the past said sometimes you do have to require certain speech, like a nutrition label from a business company, from someone who's selling food, or saying, hey, cigarettes are going to give you cancer, right? You have to put that kind of label on. Is this at all related? Like, there is precedence to compel speech somehow. Can that be done here? Why can't that be done here? I guess that's a better question. Why can't that be done here?
Well, in those cases, that is a product being sold, right? And there's a consumer protection measure associated with cigarettes, for instance. So the FDA has regulatory power to say, if you're going to sell a dangerous product, we're going to make you disclose that it's dangerous in the context of selling it. So agree or disagree, it's a commercial endeavor. It is an informational piece of information about a customer who's deciding whether or not to purchase that product. That's very different than ideological speech, where there's no customer, or there's no business aspect to the nature of it. So you're not selling anything in this context. So it's a very different place. It isn't the sort of core ideological speech that is happening in schools and in other places now.
And our founders and framers were really concerned about an intrusion into the conscience, is what they called it. And so I would say forcing teachers to use pronouns that they don't agree with, whether it's religious belief or just your own moral conscience that you don't want to say that would be a direct intrusion into your mind.
Okay. Yeah, you also don't have to fib, right? Like if they said, oh, you need to put a nutritional label on it, and you have to say it causes immediate death, right? Like there's a difference between having to say factual information and then having to say very non-factual information, or at least controversial information.
Okay. That satisfies my curiosity. We do have a couple questions that are here. If you don't mind, I want to get to them because there's a couple of really good ones in here. Victoria asks, is there anything that prohibits a private school or private university from compelling a teacher to use preferred pronouns? Does acceptance of federal funding bring in First Amendment protections against compelled speech with it? That's a great question.
It's a complicated question.
Yeah.
I'm happy to take it, unless Sarah, you want to go for it? All right. Well, the private schools, so let's take a private college like Harvard, doesn't have to comply with the First Amendment. And so they can enact a speech code if they want to. Of course, some of the documents that you receive when you're considering whether to apply to school will say we're an open environment. We encourage thoughtful debate and disagreement and, a diversity of thought. So there are some cases where you might have a contractual ability to say you're suppressing my speech, even though you promised me that you wouldn't. But generally, there's no First Amendment right under the Free Speech Clause to force that. And then under Title IX, the Trump administration would say Title IX doesn't speak to that question one way or another. You don't have to adopt those speech codes, but there's nothing about Title IX that's preventing you from adopting those speech codes. On the other hand, if you are going to charge a student, you have to comply with the due process protections under the current rule in evaluating the evidence against that person and how you could go about disciplining them. And then again, Sarah and I, when we were working at the department, our rule said, again, you can never show to the Civil Rights Office at the Department of Education that you succeeded in preventing harassment by showing us that you suppress a lot of speech. So if Harvard took that piece of evidence to the Department of Education, the federal government, which is bound by the First Amendment, could never say, good job, you're off the hook on Title IX.
Okay. So, Sarah, do you have anything else to offer that? Because I think that answered the question pretty well.
Yeah, Will did a great job. I would say these private universities are often governed by their own speech codes, and so we've encouraged at the Heritage Foundation a lot of good organizations doing work in the space. Speech First, for example, has actually brought a lawsuit against the University of Central Florida. Great outcome, essentially invalidating their speech code for precisely a basis like this. Now, they, of course, receive state funding, but the private university speech code is sort of the wave of the future for whether or not you'll have the ability as a student in modern America to be able to say what you want. But I'm thinking, if I had to predict and throw a dart at the board, we're seeing right now, for example, 2 race-based admission cases at the Supreme Court, and they're dealing with a private and a public university. And I think we're getting closer to the point where there's going to be recognition that these kind of speech protections at public universities should also inure to students at private universities. We're not quite there yet, but I'm hopeful for that day.
Does it keep you up at night worrying about your kids going to college?
Yeah, and I can't home college them. So I don't.
That's a great point. You can't home college them. You got to solve this problem now before they have to get there. We've got our first kid on the way, and I'm already knocking on the doors of our school district. Like, I'd like to see your curriculum now, please. Because if I need to change, I need to get into this now. Okay, another question here from someone called Anne. Why does it appear so important to the Biden administration, given that the number of people it impacts is so vanishingly small? It seems like this is a long-term political loser. Now, I know you're all lawyers, but we're all political animals, so we can evaluate this. This does seem like such a small portion of the population that has just become a colossal political football. What is going on here? Why? Will, Sarah, you were both in that kind of bureaucratic area. What's their mentality? Why is this so important to them?
Well, I would posit what is strictly a theory, though some people have written about this for about the past 10 to 15 years or so, that so much of this is motivated by money, right? If we can change gender identity within the context of education, and it naturally implicates healthcare. We know, for example, there's a portion of the Affordable Care Act, Obamacare, Section 1557, that actually incorporates Title IX's definition of sex. By reference, if we can change education, we can change healthcare. And if we change healthcare, pharmaceutical companies and medical organizations, big hospitals, those who are recipients of federal funding, those too will have guaranteed income as well. But it is a precipitous rise, absolutely, in what was previously a marginal percentage, 1/10 of 1% of the American population as of about 10 to 15 years ago. So it's increasing predominance in the American dialogue. The appointment of, for example, a transgender individual to a high-level political appointee position at HHS, so much of this is motivated by money and leading with education. I think this is the administration's desired end, is to entrench what is an ideology that is left of center for a group of individuals who are proportionately much, much smaller than everyone else.
So it's kind of just a wedge, right? Use kids to drive home the point everywhere else. You've said this before, just a little bit ago, and I want to make sure. How did Title IX get so entrenched in everything? How did it become that understanding, that definition got everywhere? How did that happen?
Well, I think.
Go ahead, Sarah.
I'll answer very briefly, and then I'll let Will jump in. Ultimately, because of its incorporation and just so many other federal statutes, this has always been, for our part, the brass ring for this administration, right? So it was one of the final agencies to issue its notice of interpretation, almost as if it was sort of holding out to make sure it had the most legally defensible position, was coming from the Department of Education. Department of Justice immediately issued their notice of interpretation. HHS issued their notice of interpretation. The clock was ticking. Department of Ed finally comes out and says, yep, and for our purposes, Title IX will also include gender identity. Well, unfortunately, that's had definitely a trickle-down effect to the other agencies as well, but it is naturally that particular civil rights law that is implicated in so many other places that we're seeing it really rise to predominance now, particularly within that sports context, because we're seeing high school girls, middle school girls, collegiate athletes edged out of performance scholarships, admission slots, rosters by biological males who identify as female. So it really gives us a crystallized picture of what the conflict looks like in real time.
Yeah, and I was just going to add, don't underestimate the laziness of bureaucrats who say, we've got something already written on sex discrimination, let's plug it in right here.
Sorry, that shouldn't be as funny as it is because it's terribly depressing, but that is hysterical. Don't underestimate.
Then you have some sort of like statutory consistency. It's just like the definition of firearm is used in sentencing guidelines. So they're trying to have some consistency, even though in Bostock they said this doesn't go past Title VII. And tell me if I'm wrong, but I believe in Title VII it says because of sex, and in Title IX it says on the basis of sex. And if you parse those statutes out, they're actually very different.
For those of us who don't speak in numbers, what is Title VII?
It has to do with employment discrimination.
Okay. Perfect.
Yeah, Bostock ruled under Title VII that you can't fire an employee for being transgender, but that's Title VII, not Title IX.
Mm-hmm.
Okay, so there's clear distinctions between 7 and 9 and how they approach this issue. And Bostock, that case with Justice Gorsuch, was on 7, not 9, and yet somehow the Department of Education said, we're going to do it anyway. So, because why not? Because they like to push buttons. Okay.
The department didn't read the whole opinion or even the first paragraph, apparently.
I think they probably read some headline or another, right?
Yeah, exactly.
I have one or two more questions here. Are we heading towards public schools having to teach gender or gender theory in the classroom? That's a more projection kind of thing. So not expecting crystal balls here, but if you've got a feeling, I'd love to hear it.
Listen, I love to prognosticate because I'm always right. But I'll tell you right now, we are actually in that space already because we are seeing informal interpretations of Title IX coming from these federal agencies, and they are creating rules based on those particular statutes. We are seeing the trickle-down effect in publicly funded schools already. And so much of what we were fighting under Title VI and the teaching of critical race theory, because it required an individual to affirm a belief maybe they didn't have, we're seeing again in Title IX, and now teaching of principles that for some people might be anathema to their sincerely held political, philosophical, or religious beliefs. We're seeing this at the ground level. And again, not to sound like a conspiratorialist, but if you allow the public education environment to really be sort of the sacrifice for the next generation of concretizing those beliefs, you've really lost the war to a certain extent. So we've already seen it in public education, and I think we're going to see more of it.
Wow. Okay. Listen, by the way, I love conspiracy theories. They're my favorite thing. And the best thing about conspiracies is that it's just that. Doesn't mean it's wrong. Just means it's widespread or more so than it should be. Okay, I don't like ending on that note. So I would like to end a little bit more positive. What are we doing about it? What are we doing about that whole dimension? What are we doing about Title IX? what actions is Mountain States and Heritage Foundation, what are we doing proactively to push back against this problem?
Well,
Well, we're in the trenches on this. Go ahead, Kaitlyn.
Oh, sorry. Well, Will and I filed a comment, so the agencies have to read your comment, and we put a lot of links and a lot of things for the agency to read up on to understand why their interpretation is improper. And you can also litigate over it. So just like Tennessee and 19 other states sued over that notice of interpretation, that's another way to join the fight. And, we're writing an amicus brief for that case at the Sixth Circuit. So those are the two ways we're helping now.
And that case is Tennessee v. Department of Education?
Correct.
Okay.
And that'll be filed on Monday. So just a few days from now.
Mm-hmm.
Sweet. Can't wait to see that. No, Sarah, what's going down in your neck of the woods? This is your time to shine, shine Heritage up. Well, what's going down in your neck of the woods?
Well, I'm tired a lot, so that'll give you a sense of exactly how deep I am into this fight. Listen, I was telling you all before this started, I have skin in the game. I have a daughter who's a varsity volleyball player who is vying for a college scholarship right now in her own admissions process. I benefited from Title IX myself. We led a coalition of organizations submitting comments. We encourage people to get involved, right? So this rulemaking process is designed for the American public so that our federal agencies, the executive, are not making rules behind some shadowy veil and not providing an accounting to the American people. And suddenly rulemaking has itself risen to new dominance, new predominance. So we encourage people to file comments. As it stands now, there were about 224,000 comments that were submitted to the Department of Education, higher than any other federal rule that's been proposed through the Federal Register. So they got a lot of work to do to finish reviewing those comments, but there is quite a bit of federal litigation already pending. Will and Kaitlyn already mentioned Tennessee versus Department of Education. That's a case that enjoined or stopped the informal guidance for a coalition of 20 states, because again, you can't make a rule by simply saying, we're making a brand new rule. We're upending everything we know about non-discrimination law, and you're just going to have to deal with it. So it implicated something called the major questions doctrine. That's, I'm sure, for another day, but we also are coordinating a network of public interest law firms who themselves have been submitting amicus briefs in a lot of these cases, among them Tennessee versus Department of Education. And I am writing just about every day on some aspect of this controversy and all of its many iterations. So Heritage and Mountain States together do a great deal of good legal work, and we're just thrilled to be working alongside you guys.
I'm spectacular. Sorry to hear that you're tired, but I'm glad to hear that there's plenty of work to go around.
If she were well rested, I would be worried about the world. Yeah.
Well, perfect. Well, we're going to close out here. I'm going to give each of you kind of a last minute thing to, if we didn't touch on something, if I didn't get time to ask a question, this is your time to say, hey, this is what you should know, and then we will close out. So, Will, how about you first?
Yeah, well, obviously, this is a speech issue. So we've talked a lot about sexual orientation, gender identity, due process, but this is squarely within MSLF's range, because we need to protect the rights of Americans to be able to say and not say what they want. And when we talk about the government compelling speech, compelling affirmation, and compelling even belief, that's the kind of thing that seeps into the public consciousness and that we have to fight at every step of the way. So whether it's the comment or the amicus brief or the future litigation or the work with Heritage, MSLF wants to push back on intrusive, anti-constitutional, unconstitutional actions. And we look forward to staying in this fight, being in the trenches, and winning at the end of the day.
Fantastic. Sarah, how about yourself? And then Kaitlyn, we'll have you kind of round us out.
Well, Title IX is sort of the little statute that's invited big controversy here lately, and it shouldn't be controversial. It was passed 50 years ago on a basic understanding of human biology and human sex to provide equal opportunity for everyone. Unfortunately, in this rule that we're seeing, we've elevated one group of individuals to a greater advantage than others. And that turns the whole notion of equality and anti-discrimination law on its head. So women like my daughter are now being asked to share private spaces or overnight accommodations or sports teams with biological males. So it's something that we feel very passionately about because it doesn't just implicate speech, but these are fundamental constitutional principles about equal protection of the laws and equality under Title IX. So we're going to keep up the fight.
Excellent to hear. Kaitlyn, take us home.
Whenever I started working on this with Will, I was thinking to myself, how does Title IX implicate speech? And it's really tangled. Like Will talked about in the beginning, it's hard to really divide everything out into just speech or just issues on, sexual orientation or gender identity. But that's the point, is that all of these rules and regulations are, if you look really closely, they're probably violating your free speech rights. So that's what we're digging to do here at Mountain States, is find those ways that the government's trying to be sneaky and compel your speech. So it's been a joy to work on Title IX. It's a really interesting practice area, and I hope to see some success in the cases that we're writing amicus briefs for.
Excellent. A small law with big controversy. I think that's a perfect way to describe Title IX and how it talks about free speech. So with that, thank you all for being excellent panelists, and thank you to our listeners for joining us on this episode of So Neighbor Asked. And thank you especially to Sarah for being a very, very special guest. Within a week, we should have this webinar edited and uploaded to YouTube for your future viewing and to share with others. In the meantime, you can be sure to keep up to date with all of our important work, including Tennessee Department of Education, at our website at mslegal.org. You can follow us on Twitter at MSLF, Instagram at Mountain States Legal, or you can find us here on Facebook. And of course, follow the Heritage Foundation. They have plenty of great resources on this as well. Thank you again, and we look forward to seeing you next month. So long, everybody.